Well, welcome everyone to this live stream session. Thank you for joining me. I said me, well, who am I? Well, I'm Lior Samfiru, the employment lawyer with Samfiru Tumarkin LLP, and this is my live stream session. Again, Samfiru Tumarkin LLP, my law firm. You can find us across Ontario, BC, and Alberta. If you're an employee and you're looking for someone to help you with your employment law issue, we're the biggest firm in the country. We've got your back. We have all the knowledge, information, and resources to help you. And this is my live stream session when I come on here on social media to answer your questions live about employment law, about workplace issues. This is such an important topic, right? This is always an important topic because we have jobs, we need to know our rights. But man, oh man, is it more important now than ever? We've all heard about what's going on with our neighbors south of the border with tariffs and other restrictions. Many people's jobs have already been impacted. If your job has been impacted, if you're losing your job, put on a temporary layoff, suspended, reduced your hours or pay, you got it right now. Ask the question, type it in right now, and let's get you some information. Let's get you some answers and help. You can do that right now. No one is better suited to help you than myself in this session. So let's make sure that you get some answers. Don't be bashful. Every week I get lots of questions. I want to get them right now as well. But of course, beyond this 30-minute session, there's other things that you can do. If you want to reach me and my team to have a private chat, very easy to do. All you have to do is go to employmentlawyer.ca. Again, it's employmentlawyer.ca. You see that address on the screen below. And when you go there, phone number is there if you want to use that. The email address is there if you want to use that. If you prefer to fill out a form and have us call you, easy. It's all right there at employmentlawyer.ca. But right now, I'm live, you're live. If you're watching this session, you'll learn a lot. But beyond just learning, you can also ask your question. Make sure you get some answers. Make sure you get some help and support so that when you're facing that workplace issue, you'll know what to do. You'll know how to deal with it. This is the point. Maybe you're not being treated properly at work. Maybe your boss is just not doing what it's supposed to, and they're taking out on you things that they're not supposed to. Put you on a performance improvement plan. What does that mean? What to do about it? How can you deal with it? Ask the question. I think you get the idea. I'm going to start answering the questions right now. You have lots of time. Please ask the question. Again, I'm Lior Samfiru, the employment lawyer with Samfiru Tumarkin LLP, and you're watching me live right now as I am waiting for your question. Yes, you. All right, let's see. Our first question of the day comes to us from YouTube from Growing. I'm a 12-year employee, and our company was just sold to new owners. My tenure does not change, but I have been given a new employment contract to sign, and there's a paragraph about limiting severance entitlements. Will signing mean I am waiving my rights to severance pay in the future? Absolutely, it could mean that. If you sign an employment agreement that limits your termination entitlements, at some point, that could cost you tens of thousands of dollars. It could even cost you hundreds of thousands of dollars. It's one of the worst things you can ever sign. Essentially, what you're telling your employer, hey, employer, you can let me go at any time. And if you do that, don't worry about paying me what I'm owed. Take it easy, employer. You don't need to worry about that. That's what you're signing. Don't do that. You have significant termination entitlements. You could be owed as much as 24 months pay. Now, for you, you've been there for 12 years. I don't know, of course, what your job is and your age, but let's say you're owed a year's pay. It could be much more than that, but let's say you're owed a year's pay. Well, if you sign this and you're let go a month later, instead of a year's pay, you could be looking at 2 months' pay, 8 weeks. You get the idea. It could cost you a lot of money. So what do you do here? Well, first thing you would want to do is tell this new company, hey, company, I can't wait to start, very excited, but I want you to make this change. I'm not comfortable with that. Oftentimes, they'll agree to do that, and life is good, you continue. If they don't agree to that, well, ultimately, you have to decide what is better for you. Is it better not to sign that and lose your job and get your severance? Or is it better to sign that and then at some point you know that if you lose your job, it's going to cost you a lot of money? It's your decision, but at least try to negotiate it. By the way, there may be other terms in that employment agreement that are unfavorable. So here's the best advice I'm going to be able to give you. Reach out to me. Let me see that employment agreement. Let me review it and tell you what it means and what it does. And once we do that, we'll know exactly what we're up against. Very, very important question. By the way, same with you watching, if you're asked to sign a new employment agreement, watch out for that term that limits your severance. It could cost you a crazy amount of money. Okay, be careful with that. Thank you for that question. Again, thank you for joining me. You see how easy it is to ask questions. I'm Lior Samfiru, the employment lawyer. I was just answering a question. I'm going to continue doing that. I see a bunch of questions are coming in. Please keep them coming. I promise if you ask a question, you will get an answer on this session, all right? So let's make sure we do that. And I'll continue answering. Why don't we go now? Next one from Winter Bunny has our question. My employer has told me that I'm not allowed to find another job. Okay. After having my shifts cut frequently over the last few months, I'm no longer working enough to pay my bills. I told my employer I'm going to have to find another job and was told that I could not because they need my full availability. Can they do this? I'm under contract and they said if I quit, I must pay them for training. I need a drink. This is just ridiculous. Absolutely ridiculous. So first of all, you can always look for another job, but that's not the issue. The issue is that they're not allowed to do what they're doing, which is to reduce your shifts and pay that way. That's a constructive dismissal. When your employer makes significant changes to the terms of employment, you may be able to treat that as a termination and get severance. So not only can you look for another job, you're owed compensation by your employer. Okay, that's what's at stake here. So what they're telling you is ridiculous. Your employer cannot just do that. Think about it. If your employer can just say, I know you work 40 hours a week, but from now on, we'll give you 30. And next week, we'll give you 10. And then we'll give you 2. Can't do that, obviously, right? That's a significant change. That's a constructive dismissal. So here's what I want you to do. I want you to reach out to me. I want to see that contract that you've signed. I want to obviously get some more details about you, your job, your compensation. Don't wait on this. If you wait, you're going to be considered to have accepted what your employer did. Terrible thing. And if you've accepted, you're stuck. Reach out to me. Let me see that contract. Let me help you, all right? To connect with me, very, very easy to do. Just go to employmentlawyer.ca. Again, employmentlawyer.ca, the way to do that, the place to go, and I'll be happy to help you. Two very important questions. Man, we're off to a great start today. So thank you for that. If you're just opening your computer and joining us, I'm Lior Samfiru, the employment lawyer with Samfiru Tumarkin LLP, and I'm here live answering questions about employment law, about workplace rights, telling you what you need to know about your job and your legal rights in the workplace. Questions are coming in. You guys are awesome. Thank you. I'm going to continue answering questions. Let's get to it. Amy has our next question. If someone was let go and given a severance package, do their plans to start a family impact what they should expect? Yeah, absolutely it could. Because if you're pregnant or about to be pregnant, that's going to impact your ability to find another job. So that means you should be getting more severance than you would have otherwise. Anything that affects your ability to be reemployed, anything that affects your ability to find new work is a factor that can increase your severance. So if you're pregnant now, you're going to be pregnant soon, you can't look for a job necessarily the same way, or the likelihood of getting a job is smaller than it would be otherwise, then Amy, yeah, absolutely, your severance should increase. But here's the thing. I can tell you right now, even if we put this pregnancy issue aside for a second, that regardless of that, whatever you've been offered is probably not adequate. And the reason for that is 90% of the time, 90%, it's not adequate. You're owed much more. So you're probably owed much more even if this family, starting a family issue was not a factor. The fact that it is a factor means you get even more. So Amy, if that's your situation or someone that you know, you got to reach out to me, okay? Let's discuss this. Let's make sure we review what you're owed and get you what you're owed. Amy, for you or whoever you're asking about to connect with me, very, very easy to do. You can do that ASAP. And you simply go to employmentlawyer.ca. You see that right there. Employmentlawyer.ca. Phone number is there. Email address is there. All the contact information that you need. And by the way, if you have a follow-up question, Amy, you got it. I'm still here. Questions are still coming in. That's awesome. Thank you. Again, I'm Lior Samfiru, the employment lawyer, live answering questions. Ask yours. You got time. Kathleen has our next question. Let's see. Kathleen says you are given working notice of 18 months. You find employment within the notice period, but your new employer does not offer benefits. does the former employer have to pay throughout the notice period? So strictly speaking, if you were to quit because you found another job, then you don't get any more severance beyond that point, okay? So you got 18 months working notice, let's say, 5 months in, you found another job. Irrespective of what that job is, if you quit to take that job, unfortunately, you do not get any more severance or other compensation because you've resigned. So when you resign during the working notice period, or if you leave during the working notice period, it's considered a resignation. Even though it is still your employer that told you you're not going to be working, despite that, ultimately, it is a resignation. All right, so you have to keep that in mind. And again, if you have any follow-up questions, Kathleen, I'm still here. You can ask it. You got time. I'll be happy to connect or answer follow-up questions. So thank you very much for that. All right, Sheila. Sheila has our next question. Does the new changes to EI March the 22nd that claims to be for 6 months about not having to have the severance run out apply if the severance is more than a year long? Yes, as far as I know, it does apply so that you can ultimately have the severance and the EI. Keep in mind, if you let go and you're looking at a severance issue, EI is the second thing you worry about. The first thing you worry about is to make sure the severance is adequate. Because again, chances are it's not adequate. I can almost guarantee you that. But yes, it would apply always. By the way, guys, I've talked about severance a few times. Let me take a moment here to tell you more about severance and how you can find out what the right severance amount is for you. You can do that so easily, so quickly, and of course for free. All you do is you go to pocketemploymentlawyer.ca. See that address? Pocketemploymentlawyer.ca. Once you're there, you click on the severance calculator. That's it. You're there. Pocketemploymentlawyer.ca, click on the severance calculator, and you can find out in seconds how much severance you're owed. You answer a few questions, you click on the button, and it's going to tell you 6 months, 8 months, 24 months, whatever the right amount is. Completely free, completely anonymous. Well over 2 million people across Canada have already used it. Make sure you do as well. You can use it if you're staring at a severance package and you want to know if it's fair. You can do that if you're worried about losing your job and you want to be prepared, or maybe you're just curious. And by the way, man, it's not a week per year of service. It's not 2 weeks per year of service. It's much more. Check it out yourself. Again, pocketemploymentlawyer.ca should always be the first place you go to if you lost your job. All right, let's see. Next person on the list. By the way, before I do that, questions are coming in. Love them. You got time still. Don't wait till the end of this session to ask question. Ask it right now, because now you have time, and I have time to read it and answer it. If you ask a question 30 seconds before I'm done, I'm not going to get to it. So right now, ask your question. Again, I'm Lior Samfiru, the employment lawyer with Samfiru Tumarkin LLP. Just like Gail did. Gail has our next question. I was bullied. My boss blocked me from moving to different departments. I ended up going on mental stress leave. Insurance denied my claim, went back to work. I had a panic attack, on medical leave now. Okay, so the first thing is, let's talk about insurance. They denied your claim. If it's still denied, if you're not getting insurance benefits, short-term or long-term disability benefits, then let me help you. We have a whole team dedicated exclusively to helping people that have been denied disability benefits. That's how often it happens, and we need to have a whole team dealing just with that. So Gail, if this issue with the insurance company is not resolved, reach out to me. I can tell you we're going to get that resolved. You can reach me through employmentlawyer.ca. But let's deal also with this issue of bullying. The key is to be able to prove it. Remember, the person that's mistreating you or bullying you is not going to admit it, right? You ultimately have to prove it. If you have that proof, that could be a constructive dismissal, all right? We could potentially get you out of there with compensation. For now, one of the things you may want to do if you haven't done already is go to HR. Tell HR about what's happening. They have to investigate. They have to take it seriously, and they have to do whatever possible to fix it. And if they don't, if they ignore you, if they don't do a good job in dealing with it, that could be a violation of several statutes. It's illegal. So I like the idea of giving your employer the opportunity to fix this. If you've tried already and that hasn't worked, you want to reach out to me. Keep in mind always, you need to have some ability to prove, whether it's some email or someone to corroborate you or some other way where someone can look at this and say, we now know that Gail was being bullied or mistreated, right? Because whoever the boss is, they're going to deny it. Okay, Gail, hopefully that makes sense. Hopefully that explains things for you. But certainly, if your insurance company denied your benefits, short-term disability benefits, long-term disability benefits, don't let them get away with it, all right? Call us, okay? As soon as possible, we'll help you. And to reach me and my team, very easy to do, employmentlawyer.ca. Again, employmentlawyer.ca. All right, fantastic questions so far. Really amazing questions. You got time. I know you're watching, so why don't you ask your question as well? Let me help you. I want to continue answering questions because that's what I'm here for. So I'm going to go next to Christine. Christine says, my employer changed my hours from 5 a.m. to 3 p.m. to 7 a.m. to 4 p.m. with no notice. I'm non-union. I refuse to sign the paper to agree to this. Would this be a constructive dismissal? Yeah, absolutely, it could be a constructive dismissal, no doubt. So ultimately, you refuse to sign. So the question now becomes, what are they going to do? If they back off, so they say, okay, Christine refused, we're just going to back off and let her be where she is. Okay, then no problem. If they don't back off and say, well, too bad, we're going to do it anyway, we're going to implement it anyway, we don't care that she refused, then let's talk about constructive dismissal. You may be able to treat this change to your hours as a termination, as a constructive dismissal, and leave with your full severance. So that's what we need to discuss. Obviously, I want to understand some of the history. How long have you worked in that 5 a.m. shift? Has it always been the case? Have they changed your hours before? All those things are valid things for us to discuss, important things for us to discuss. So I'd want you to give me a call, Christine, before you do anything, before you walk out of the job. Don't ever do that without speaking to me first. And you can reach me, of course, very easily through employmentlawyer.ca. Look at that address. It's right on the screen, employmentlawyer.ca. The reason why I've been doing these sessions for years, I host a radio show that I've been doing for 12 years, a TV show that I've been doing for about 10 years. The reason I'm doing that is because there are so many misconceptions when it comes to employment law. There's so much misinformation out there. People believe things that are not true. It drives me bananas. Sometimes I go online and I read, oh, this is the law, that's the law, and it's all wrong. Please don't let that happen to you, okay? Don't go on Google and try to figure out what the law is, okay? It's a dangerous place when it comes to your rights. If you had a serious medical condition, you'd go to see a doctor, right? You're not going to look at a message board on Google and say, well, this message board says I have a medical condition. No, you're going to go see an expert. Same thing with your legal rights. If you have a legal issue, let's talk about it. If you don't like me, then speak to another lawyer. That's okay. But you have to get some legal advice. Don't walk away from your rights. Do you know how many times people reach out to me, let's say after they signed the severance package because they thought they had to. And they call me after they signed when they realize, holy cow, I was owed twice, 3 times what I was offered. And I have to tell them, I can't help you because you signed it. The time you should have called me, it was before you signed it. That's just one example where people walk away from their rights. Don't let that happen to you, okay? Let's always have a conversation. You can call me on the radio show. You can send me an email. You can ask questions here. And of course, employmentlawyer.ca, your one-stop shop to reach me and my team and get a lot of information. All right, but right now I am live. You're live. Ask your question. You got time. Let's continue answering. Alarmed has our next question. I was terminated after 6 years with this company. I'm a flat rate mechanic that gets paid $30 an hour based on book time and warranty labor times. I'm terminated with cause, and the letter proceeded to cite 3 work orders that were not provided. They were not provided for review, saying that mistakes were made and it cost the dealership. When I questioned them about the orders, no further info was provided. The timing is odd, as I just returned after a parental leave of 4 weeks. They will only be paying me my vacation and subsequent hours from this pay period only. This is a first for me. What can I do? So here's the thing. To terminate your employment for cause, i.e. without severance, man, you would have had to do something pretty nasty, really, really bad. It's not enough for them to show that you've done something wrong. It's not even enough for them to show that you've done a few things wrong. They would have to show that what you did is so bad that that's it. It's just not possible to employ you. And if you haven't received warnings and you haven't received training if there was issues, it's not going to be possible to terminate you for cause. So this would be a termination without cause, meaning you're owed severance. Now, if you've been there for 6 years, you're a mechanic, you could easily be owed 6, 8, even 9 months of pay. Okay, so significant entitlements. Now, the other thing is this, and you made the point, everything goes well, no problem, life is good. All of a sudden, you take a parental leave and you come back, that's it, you terminated for cause, you did things you didn't even hear about. It does make it seem like you were let go maybe because you took parental leave. Well, if that's the case, this is a human rights violation. This potentially is an employment standards violation. In other words, it's illegal. You cannot be let go, even if part of the reason for that is the fact that you took a parental leave. Can't do that. So we potentially have that human rights violation. Of course, we have the wrongful dismissal because you're owed severance. So, Alarm, you got to reach out to me, okay? We got to speak as soon as possible. Let me help you get what you're owed. You obviously have significant entitlements here. Don't let an employer get away with that. To reach me and my team, so easy, so simple to do. You just go to employmentlawyer.ca. You see that address there, employmentlawyer.ca, and let's have that chat. By the way, if you're just joining us for the last 10 minutes or so of the session, welcome. I'm Lior Samfiru, the employment lawyer, and I'm here answering questions live. Ask your question as well. All right, let's make sure we get those answers to you right now. You got time still. I said 10 minutes. That's tons of time. So ask your question. I'll get to it and I'll answer it. All right, just like Shane. Shane says, I'm being laid off after 9 years of employment. I was given 3 weeks notice and 8 weeks of pay. Is this enough severance? It's not. I'm not sure if I should accept or not. You should run far away and not accept. So the 3 weeks notice does count towards your severance. So you got 3 weeks plus 8. So you got 11 weeks after 9 years of employment. Now, I don't know the type of job that you were doing, and I don't know your age, but after 9 years, it's never going to be less than 6 months pay, and it can easily be 12 months or more. You were offered, let's call it 2.5 months or so. You're owed a lot more. It's probably 3 to 5 times what you've been offered. So no, it's like me saying, hey, I owe you $100, but I'll pay you 20. No, why would I do that, right? If I owe you $100, I should pay you $100. You're not going to accept 20 if I owe you 100. It's the same thing. That's a terrible offer. It's an offer meant, it's almost highway robbery. It's meant for you to accept without knowing any better. Now you know better, Shane. So you reach me, okay? Employmentlawyer.ca. Again, employmentlawyer.ca. So let's see. Next question comes from Barney or Barneys. Do you think the problems with the U.S. will change our employment laws like during COVID? Well, I can only see that happening if our government see that the workforce has been impacted in a very significant way. Remember during COVID, everyone was losing their job or people put on temporary layoffs. It was like hundreds of thousands of people in the span of a couple of weeks. That's how bad it was. So it would have to be something pretty massive for there to be changes to employment laws. At this point, we're not there. I hope we're not going to be there. But certainly if something massive happens, governments can't ignore that. But right now, we don't see that. And, our economy generally is operating. People have been affected. Absolutely. I speak to people like that every day. But it's not such a wide scale as happened with the pandemic. Thank you for that question. And we'll see what happens. But at least either way, whatever happens, I'm here. I've got your back. You can always reach me through employmentlawyer.ca. Again, employmentlawyer.ca. All right. Let's see. More questions. Marsha, how's that? Marsha says, I was getting a rate with one contract last year and then now getting a new rate, which is lower than last year's. They said last year's rate was calculated in error, but when I ask, they won't answer me. So I would need a lot more information. What rate are we talking about? The commission rate? What kind of rate are we talking about? Does your rate change every year? Or is this a new thing? Does it sometimes go up? Does it sometimes go down? So I would need that context to be able to answer you, all right? So best advice I can tell you at this point is let's connect and have a conversation off air. You can reach me through employmentlawyer.ca. Again, employmentlawyer.ca, because that could absolutely be a constructive dismissal, it may be illegal. But for me to tell you that, I need some context, right? I need some more information, just like I was saying. So employmentlawyer.ca, the place to go to reach me so we can have that discussion, then I can properly advise you. All right, guys, you still have the last 5 minutes or so to ask questions. Why not kind of get your question in under the wire as well and make sure that you get an answer? Lori has our next question. I've worked for an IT company in Southern Ontario as a production supervisor for 7 years. The company headquarters is in England. Over the past month, the employer had us ship everything to their England location, so everyone knew that a layoff was coming. Yesterday, we were told that everyone is getting laid off. To make matters worse, he stated that no one will be receiving their final paycheck or any severance package, as they will no longer be operating in Canada. Should I cut my losses? No, that doesn't work that way. They have to pay you severance. And the only time they won't be able to pay severance is if they're in formal bankruptcy proceeding, an actual court bankruptcy proceeding. If they just decided to close shop in Canada, that does not relieve them of their obligation to pay you severance. And of course, you have to get your final pay. This is absurd. In fact, with final pay, the directors of the company are personally liable. They're personally liable for that final pay. And of course, severance has to be paid as well. Very important to remember, just the fact that a company is not doing well or shutting down does not relieve them of their obligations. Bankruptcy is a very different thing. Like with HBC recently, we heard bankruptcy. That's different. But shutting down, relocating, very, very, very different. So, Lori, you got to reach out to me. But don't wait on this. We don't want the company to disappear and then we're chasing a ghost, right? You got to reach me through employmentlawyer.ca. Again, employmentlawyer.ca. All right, fantastic questions. By the way, I'm Lior Samfiru, the employment lawyer, and I've been answering questions, fantastic questions from you guys in the last 30 minutes or so. Let's see if I can take another one or so and make sure you get some answers. But maybe I'll cheat a bit, and if you have a question, you can kind of get in under the wire. I'll try to get to it as well. So try it. Why not? Next question is from Realistic Tax. Unfortunately, all tax is realistic. Maybe not fair, but realistic. I work as a pedicab driver, but the guy who owns the company wants us to sign non-compete agreements that says if I go to work for a competitor or become an independent contractor, an independent operator, I would have to pay the company several thousands in penalties every year for 5 years. Is this enforceable? No, it's not enforceable. But it's not enforceable at all. But here's the thing. It's never a good idea to sign the document because it's not enforceable. To say, well, I know it's not enforceable, so who cares? I'm going to sign it. No, that's not a good idea. For the purpose of signing, you have to assume that it's enforceable. Here's a couple of reasons. Number one, I'm telling you it's not enforceable, so you sign it. Well, what if the law changes tomorrow, okay? And now it is enforceable and you signed it. Now you have to live with it and pay this person thousands. Laws change, okay? The other reason is this. Let's assume it's not enforceable, it's complete garbage. Well, what happens if this company that you work for tries to enforce it? Now, they will lose, but they will still cost you thousands and thousands and thousands of dollars to fight this, and who needs that? So I would not sign something like this. It's absurd, it's ridiculous. It's always a bad idea to sign something on the basis that it's just not going to be enforceable, okay? Not responsible. If you want me to take a look at it and give you some more information specifically about this document, reach out to me, and I'll be happy to connect to do that. You can reach me through employmentlawyer.ca. Again, employmentlawyer.ca. All right, lots of questions today. I think that's the time we have for this session. Always really good to be here with you and to talk about employment law. But the fact that we're turning off and ending this session doesn't mean that I'm going anywhere. Doesn't mean you can't get answers or help. You can continue doing that anytime, and you can do that through employmentlawyer.ca. See that address? You can reach me now, my team, phone, email, all there at employmentlawyer.ca. My colleagues will be back here on social media. I'll be back on social media, so you have plenty more opportunities, but don't even wait. Just go to employmentlawyer.ca now. Guys, thank you so much. I'm Lior Samfiru, the employment lawyer. Real good to talk to everyone, and we'll talk to you again.